where we ask that you pay particular attention to what's said in relation to things like such as post-commencement finance. So we'll deal with those in detail, and then we'll deal with any questions that you may have. Now, on on questions, please, I ask that you post your questions. You can do so anonymously. The idea is that we engage. Otherwise, we could have just pre-recorded today and played it on a daily basis. So you can ask some specific questions, industry-specific questions. That would be great, or questions specific to your company. Otherwise, what we can do is we can schedule a private Zoom meeting with you and your team. It's part of the pro bono initiative. It's part of COBRA. We would have business rescue practitioners, attorneys, and other professionals who may be required to assist in your particular business. So we can do that. COBRA has other aspects of COBRA also on pro bono. Those aspects include if you enter the COBRA ecosystem now, and in the event of COBRA not coming right and not being able to save your business, and if it gives rise to the need for a liquidation, COBRA will foot the bill for that. It's a high court application, and that's between 30 and 50,000 rands. And the idea is that if you enter COBRA, we won't get to that, and that's really what COBRA is about. COBRA is not about business rescue, believe it or not. COBRA is about avoiding business rescue. The idea is that you only you resolve to not go into business rescue because you've entered into the COBRA ecosystem. We'll take you through why you have certain obligations in that regard. That'll be part and parcel of our discussion today. So if I can just kick off by asking Ian to give us a general rundown of business rescue at a high level. Thanks, Ian.
Thanks, Maurice. Yeah, so business rescue was promulgated in the 2008 Companies Act, the South African Companies Act of 2008. And the 2008 Companies Act is perceived as being a lot more debtor-friendly Companies Act than the previous Companies Act of 1973. And business rescue was basically designed, and chapter 6 of the Companies Act written, with the purpose of giving companies sort of a last chance before liquidation, and obviously saving jobs and preserving value that would otherwise have been lost in liquidation. So the aim of business rescue, and the first business rescue started in 2011, was basically to give a company breathing space under a moratorium. And the moratorium is basically the time that the company is under business rescue. It enjoys the legal protection of business rescue, and during that time, creditors cannot liquidate the company. They cannot take legal action against the company in any way whatsoever. And we like to refer to it as a steel blanket that is around the company during the time that it's in business rescue. During that time that it's under business rescue, it is under the supervision of a business rescue practitioner. Business rescue practitioners need to be registered with the CIPC, and the skill set to be a business rescue practitioner and to do business rescue properly is very vast, because at the end of the day, the business rescue practitioner takes control of the board of directors, and the entire company really sort of reports into him. And so it's a very big responsibility. And during the time that it's in business rescue, the rescue practitioner is there to reorganize the company. He's there to restructure the debts of the company and the balance sheet of the company. He's there to restructure the organization of the company, or the operations of the company. He's there to restructure the shareholding if necessary, and with the aim of getting the business out of financial distress during the time it's in business rescue. And then at the end of the business rescue, releasing the company as a solvent going concern. Now, there were a couple of changes subsequent to the Companies Act being published, and the requirement to release the company as a solvent going concern was relaxed, and it became acceptable for the business rescue process to realize a better return for creditors than in a liquidation scenario, as opposed to necessarily returning it to a solvent going concern. The primary aim of business rescue should always be to return it to a solvent going concern, but if that is not possible, as in many cases, it's what we call the whole, the difference between assets and liabilities is too big, then it is perfectly acceptable to wind it down under business rescue and to give creditors a better return than they would get in a liquidation scenario. This is all done according to a business rescue plan. The timelines are fairly urgent in business rescue, as you can imagine. Got a company to save, business rescue practitioner cannot take his time about it. Everything is inherently urgent. Therefore, the timelines prescribed by Chapter 6 of the Companies Act are fairly tight. Within 25 days of being appointed, business rescue practitioner is required to publish a business rescue plan, and that plan basically sets out, in a nutshell, how he's going to reorganize the affairs of the company in order to return it to a solvent going concern. Maurice, I think that answers your question. Maurice, I think you're on silent, perhaps.
Sorry about that. Okay, so thanks, Ian. What I'm going to do is I'll go through aspects of the Act which are really important, and we'll start with the moratorium. So business rescue is primarily about the moratorium, as Ian said. The moratorium in this context, in the context of the COVID crisis, would, in our view, only come into effect or only become necessary in the event of a creditor being unreasonable and threatening to sue and threatening to liquidate. You know, one must be mindful that this is a no-fault scenario. The businesses are distressed because of an act of God. So what COBRA is going to, well, COBRA is doing, and what the methodology that we employ is to have our qualified mediators negotiate between the creditor, will deal with the creditor-debtor relationship, and try and get your creditors into the system so that we can then mediate and try and strike arrangements which would avoid a business rescue. And the idea is to do this throughout the entire supply chain, right down to the bottom, let's say a spaza shop, all the way up to the banks. So this moratorium will only kick in if you are involved in negotiations and there's a disparity of bargaining power because of the threats of liquidation. Then what one can do is one can resolve to put the company into business rescue by way of an ordinary resolution. So here we deal with the moratorium. You'll see it's business rescue specifically deals with the moratorium. Financially distressed is defined there. And importantly, what the moratorium does not do is the moratorium does not suspend contracts. So if you're in a position where you have, let's say, a lease agreement that's running, and you go into business rescue and you do not suspend by notice, or the business rescue practitioner does not suspend the lease agreement still remains extant, which means that the landlord could still cancel the lease. And even in business rescue, the landlord can apply for your eviction. There's a judgment by Judge Baruchovitz to that effect. That if the business rescue practitioner doesn't do it, well, then you are stuck with cancellation. So this is an important take home. Make sure that you have a business rescue practitioner, if you go outside of COBRA, who knows that it's necessary to suspend the contracts, and be ready with a list of the counterparties to the agreements so those notices can go out, obviously with contact details. So that's really, really important. Ian, you mentioned labor, saving jobs. Can you just go into more detail there, and then I'll deal with the legal aspects. But sure. I'd ask that you first deal with the practicalities, and then we'll move to how it's done legally.
Sure, Maurice. So just around the practicalities is that Company goes into business rescue. 5 business days later, the business rescue practitioner is appointed. Within 10 business days thereafter, he needs to call a meeting, which we call the Section 148 meeting, with the employees, or if the employees are represented by a union, then with the union representative. So at that meeting, he then is required to tell the employees whether he believes there's a reasonable prospect of saving the company. He has a similar meeting called the Section 147 meeting with the creditors, when we normally have them one after the other at more or less at the same time. So he then has to inform the employees whether he believes there's a reasonable prospect of saving the company, which will obviously result in their jobs being saved, or saved to a large extent. At that meeting, he can then inform them of the intention of the company to perhaps effect retrenchments, or to negotiate a solution that that is an alternative to retrenchments. During the formulation of the business rescue plan, he's then required in the business rescue plan to put together the plan around employees and how many employees will be retrenched and so on, how the employee costs will change after the business rescue, or will decrease after the business rescue plan has been approved and implemented. So obviously it's a very sensitive matter that needs to be dealt with. We have found that we have been negotiating with employees to a large extent already under the COBRA initiative, and as part of the process of the Section 189 retrenchment process, you are required to engage with them as to alternatives that can be implemented as opposed to the retrenchments. And what we're putting forward to them is the possibility of decreasing their salaries to the extent that it becomes affordable to the company during this lockdown period and the foreseeable future after the lockdown, for their salaries to be paid by the company. In other words, we are trying to reduce we're trying to make the cost of their salaries more variable, or more linked to the turnover of the company. And the employees that we've engaged with to date have been very responsive to that, and they've been very open to accepting a substantially reduced salary payment or wage payments in many cases, so that at the end of the day, once the lockdown is over and the economy can hopefully start recovering, then they will still at least have a job as opposed to being retrenched. Maurice, I hope that answers your question.
Yes, yeah, we recently dealt with the company, and what the company did is put the staff and the directors who took a cut, they all agreed that whatever cash came in after expenses would be distributed pro rata the salary bill. So if the 2 employees and only 50% comes in, they'd only get 50% of their salary. So I think that's what you're talking to, is to make it variable. The same, before I get into the legalities and details, I think the same with landlords, yeah?
Yes, very much so. Yesterday or the day before, I think it was yesterday, the Spur Group came out and said that they will, in effect, be discontinuing payments, all but discontinuing payments to landlords, except for turnover-based rentals, which in many cases would be null at the moment, with the restaurants not being able to operate. But once they're allowed to operate, it'll be they will only be able to pay landlords a small turnover-based rental. And what we've been preaching from the beginning of COBRA is this idea around making your costs variable, in other words, linking them to turnover. And turnover-based rentals, obviously restaurant owners are the first ones that have been affected by the lockdown. And amongst the people who have approached us already, the companies that have approached us already, a fairly large percentage of those have been restaurant owners, and because effectively they're not allowed to operate, and they are inevitably the first ones to be hit as a result of COVID. And what we've been saying to them, we've been taking on the negotiations with landlords, and we've been doing exactly that, basically saying to landlords, the company cannot afford to pay a full rental during this period. The only way we can see it happening and being potentially a win-win situation for both the landlord and for the company is to pay a turnover-based rental right from the time that the company can start operating. Be it 20% of turnover, be it 50%, be it 60%. That's the only way it can actually work. In the long term, the landlord is likely to benefit, because however long it takes for the economy to recover, once it has recovered, then the landlord will benefit as a result of the turnover-based rental that gets paid to him will be higher than the rental that he was charging before. So that's kind of the potential quid pro quo for the landlord.
Certainly. And you're finding that the attitude of the landlords is good, that they I mean, I guess, Ian, at the end of the day, what option do the landlords have? I mean, they're going to want a tenant when this is over, and they'll have a tenant if they agree to an arrangement like that. Otherwise, they'd have to launch an application to liquidate. And if that happens, you know, we've dealt with auctions, you get next to nothing. So it's ultimately the lesser of various evils for the landlord, and the lesser is to keep the tenant and agree to an arrangement like that.
That's exactly right. And when we're negotiating, you know, we always put ourselves in the shoes of the person who we're negotiating with. And yeah, the tenant, I mean, the landlord, where is he going to find another tenant? So landlords have they have been accommodating, and they have been reasonable, but at the end of the day, they don't really have a choice. I mean, they're in the same predicament as everybody else at the end of the day. If they evict a tenant or they liquidate the tenant, what are the chances of them being able to replace that tenant? And that's obviously the question they're asking themselves, and that's a question we ask ourselves, and that's why they've been reasonable to an extent. Yeah.
Well, have there been discussions in relation to vis major and how the landlords, I mean, do they appreciate that this is a vis major, and that's also, there's a legal impediment to them claiming the rentals, depending on obviously the wording of the leases?
Absolutely. Absolutely. Yeah. The wording of the leases needs to be looked at very carefully in relation to force majeure. And yeah, that's something that definitely needs to be considered when we're approaching discussions with landlords and so on.
I think it's important for the audience to know that one does not require a vis major clause in a written agreement. Vis major is either dealt with in the agreement, and what one often finds is that the provision says that if the vis major continues for a certain period of time, then either party has the right to cancel the agreement. But outside of that, subject to the requirements of vis major being in place, such as it ought not to have been foreseeable, then the contractual obligations are suspended. So that's obviously something that ought to be factored into the discussions. We were dealing with jobs, but before I get on to jobs and employees and Section 189, I do want to call on questions. We haven't had one yet, but please post your questions so that we can address any specific issues. So you touched on it, Ian. Employees, in terms of the Act, in terms of the Companies Act, have exactly the same rights as they had prior to the business rescue. In fact, they're given more rights. Why? Because they're recognized in the Act as an interested party, an affected party, and they have a say when it comes to the conduct of the business rescue process. The manner in which one deals with employees, there are two options. One is a unilateral variation to their employment terms, and the other one is via redundancy, where there's a retrenchment. Now, Section 189 deals with redundancy. It deals with dismissals based on operational requirements. But it also is the section that would apply if you want to vary an employee's contract, unilaterally vary an employee's contract, such as salary. Because what one does, one consults with the employees, and a reduction in salary is proposed as an alternative to retrenchment. And if the employee or employees reject the alternative, then you have to revert to a dismissal based on operational requirements. So then you'd have to pay the severance pay. Now, isn't there an issue there? I mean, if you think about it, Ian, you're a business rescue practitioner. You need to vary the contract. You're required to vary the contracts to survive. And the employees say, no, we'd rather take a severance pay because we've been at the company for 30 years.
Yeah.
You know, how do you deal with that in this time?
The practicality of that is, Maurice, and what we have experienced in the past is, does the company actually have enough financial resources or money in the bank in order to pay those retrenchment costs? And under business rescue, we have had instances in the past where the company is actually not able to pay those retrenchment costs once the employees are retrenched. And that's something that needs to be communicated to the employees during the consultation process. If the company doesn't believe, or the business rescue practitioner does not believe that the company has sufficient financial resources to be able to pay the employees their retrenchment costs, then that needs to be expressed to the employees, because that can be that's information that is required to be absorbed by both parties in order for the employees to consider whether they want to be retrenched or whether they want to take a pay cut. What we had to do in business rescues in the past, when there has been no money to pay, we've retrenched the employees where they've agreed to be retrenched, and then we've had to wait. A few months until we've either sold an asset or, in order to raise cash to be able to pay the retrenchment costs, or from some sort of operational restart or cash generated out of operations, we then raise enough money to be able to pay the employees. So that is a practicality. Obviously, it's something that we don't, we don't like to have to do, but sometimes we don't have a choice. Sometimes there is literally no money available in the company to be able to pay the retrenchment costs as they fall due.
Just on that score, can you deal with PCF, post-commencement finance? Another take-home. I'll ask you just to deal with it, but deal with post-commencement finance in the context of what we've encountered: shareholders outside of business rescue wanting to put money, lend money to the company on loan account to pay salaries. I'd ask that you deal with that in the context of business rescue and whether it's wise, and what is PCF about? Yeah,
certainly. So PCF or post-commencement finance is the finance that is advanced to a company after it's gone into business rescue. Now, post-commencement finance enjoys seniority when it comes to repayment. So if a company is in business rescue and somebody puts money into the business, then the repayment of that loan effectively falls right near the top of what we call the waterfall. The waterfall is the order of repayment of creditors. So right at the top in business rescue practitioners' fees and remuneration. And if money is advanced to the company after it's gone into business rescue, that post-commencement finance falls right below the business rescue practitioners' fees and remuneration in the repayment waterfall. So very important that if you're a shareholder considering putting money into a business that's in distress, it's better to put the money into the business once it is in business rescue. If you're putting into the company before it goes into business rescue, then that you simply rank with the concurrent creditors as far as repayment of that debt goes. So in other words, you're going to wait a long time for your money, and the repayment will most likely be compromised or reduced. The value of the debt will be reduced quite substantially in some cases when it comes to repaying it. So yeah, it's very important to remember, if you're putting money into a company, put it in once the company is in business rescue. Also important to try and secure that money via assets that are in the business. In other words, make it a secured loan, because in the event of the company going into liquidation, after it's been in business rescue, then secured post-commencement finance ranks right at the top of the waterfall in liquidation, right below liquidators' costs. So unsecured post-commencement finance unfortunately falls down the waterfall in a liquidation scenario, and ranks just above concurrent creditors. So if you can secure it, by all means do so when you're putting finance into the business during business rescue.
Yeah, I think it's important to mention that part of COBRA has turned into a marketplace. We literally have to update the background every day. That's why we haven't, but we have now dozens of partners, which include a whole host of partners when it comes to PCF. They are willing to assist on a on the basis that they'd consider it as PCF and they would be afforded that additional security. So be mindful of that as well. We've got a great question. What are the costs of business rescue? Ian, I'm going to ask you that, but before I go into it, let's just deal with it in the context of COBRA. COBRA is a pro bono initiative subject to a means test. And the way that it's been formulated is that fees, professional fees, will be written off entirely if that's required for a successful rescue to avoid a liquidation. And they'll be reduced if to ensure a successful rescue. In the event of it being impossible to rescue the business and the shareholders not getting anything, then the High Court application that I made mention of is handled on a pro bono basis. And every member of COBRA has pledged and has agreed to provide services on that basis. And you'll see that there's IQ Business as an example. They're a large business consultancy, and they're very, very competent. They've been around for about 22 years. And now you can tap into 700 of their consultants to assist on the same pro bono basis. That's what we've been, that's the basis of the people who've been approaching us, on the understanding that the fees aren't going to be a problem. And bear in mind that you're going to get the benefit of chartered accountants, economists, attorneys. You're going to be getting all that advice as part of the process. And ultimately, it won't break the bank, particularly if the writing off of the fees is required. The means test is set out on the website, so have regard to that. But on the cost of business rescue, with specific reference to engaged and how you do it, Ian?
Yes, Maurice, thanks. So yes, just building on what you said, and what's nice about this is the way that Engaged and Schindlers have worked together in the past before the COBRA initiative was started. How we worked in business rescue is that we do not let fees get in the way of a successful business rescue. And unfortunately, that's where a lot of business rescue practitioners have gone wrong in the past since business rescue started in 2011. They've let fees literally break a company. They've let business rescue fees break a company, and that's why so many business rescue, that's one of the reasons why so many business rescues end in failure and end in liquidation a few months later. So yeah, very important message coming across. That's how we have operated to date, and that's how COBRA operates. We do not let fees get in the way of successful business rescues. The question of what are the costs of business rescue? The costs of business rescue are dictated by Chapter 6 of the Companies Act, which was written in 2008, as I've mentioned before. So the costs range from a small company, a business rescue practitioner is entitled to charge 1,250 Rand an hour, to a large company where he's able to charge 2,500 Rand an hour. Now, these fees are considered by most business rescue practitioners to be outdated, and in the sense that they were written into the Act 12 years ago. So, for 2,500 an hour, it's very difficult to find a competent, senior business rescue practitioner to do what is required to do in a business rescue, to bring the necessary skills to the party and apply those skills properly. So, what most business rescue practitioners do nowadays in medium to larger companies that can afford to pay their fees is that they, right from the outset, they tell the company, our fee is X amount. Could be 3,000 Rand an hour, it could be 3,500 Rand an hour, and they ask the company's management firstly to approve that, and then as part of the approval of the business rescue plan, then they ask the creditors to approve a higher fee than is legislated by the Act, and that is normally accepted. Most institutions and most creditors do accept that the fees in the Act are outdated. However, yes, but the most important thing, as Maurice has correctly pointed out, is that affordability in COBRA is the number one thing, and to do business rescue responsibly, affordability needs to be the number one criteria when determining what fees to charge. We also tend to charge a contingency fee, and a contingency fee is prescribed by the Act to be a fee that is linked to actual successes being achieved in the business rescue processes, either as milestones in the process or as a success fee at the end of the business rescue process. Very important, and contingency fees are important. You know, professionals, good rescue professionals, need to be incentivized, you know, to achieve success in the business rescue, to fix the company, to return it to a solvent going concern, or provide creditors with a better return than in liquidation, as the case may be. So contingency fees are actually important in order to be able to attract the best business rescue and turnaround professionals to specific matters. So, but it's very important that they be structured on the basis that they are based on real success. Practitioners in the structured fees that are contingency fees to be payable upon the business rescue plan being approved by the creditors. Now, we don't consider that to be a real success. It certainly is not a success in the implementation of the business rescue plan. And unfortunately, it gives rise to conflicts as well for the practitioner, because if he isn't being incentivized monetarily to have a business rescue plan approved, then there's a strong likelihood that he will cave into the demands of creditors in order to get that business rescue plan approved. And he might cave into the extent that it makes the plan unimplementable. In other words, the plan, the creditor's demands might be so extensive that the business rescue plan, the practitioner agrees to those demands, and then it's because of those demands possible to implement the business rescue plan. So these things need to be considered. I mean, these conflicts need to be thought about very seriously, and we need to, when structuring a business rescue plan, and especially when it comes to contingency fees and that sort of thing, we need to try and avoid conflict as much as possible.
Absolutely. To move on to negotiating fees now with the directors, the board of directors, you start dealing with the board prior to going to business rescue. The relationship there is amicable. You work together. It's a team effort. Now you go into business rescue, and the directors have certain obligations, and I'll take you through those obligations, and then we'll move to Ian to understand how it operates practically. The obligations, the fiduciary duties in terms of Section 76 and 77 of the Companies Act remain extinct. The directors still have that duty. However, there's an additional burden on the directors, and that is they have obligations towards the business rescue practitioner to assist the business rescue practitioner, to point out where any records are, to hand over those records, and essentially to come up with a plan with the business rescue practitioner. Interestingly, what in effect happens is the directors become a statutory employee, in a sense, of the business rescue practitioner. But now that sounds scary, Ian. In practice, I mean, how does it work? Are the directors in a compromised position?
Well, the directors, I think the directors are very often relieved to have somebody take over, the ultimate responsibility for the board. It also talks to the necessity to appoint the correct business rescue practitioner, because you need a business rescue practitioner who can work with your board. You don't want somebody to come along and sort of think that they can run your company better than you can, just because. And we always say when we walk into a new company, we will never be able to duplicate the relationships that company and the board of directors has built up over many years with their creditors, with their debtors, or let's say with their suppliers and with their customers, and with the public at large. They will never know the intricacies. The business rescue practitioner can never know the intricacies of the business as well as the guy who started it, or as well as the board of directors who have been there for a long time. So very important that we establish a good working relationship, that we can work together. So yes, the board of directors does report to the business rescue practitioner, and that's why that's why the role of the business rescue practitioner to try and have the right person in that place is so important. and the directors carry on with their normal duties. Yes, it is very important, and the Companies Act prescribes that the directors give the business rescue practitioner their full cooperation, or that they assist him in every possible way to carry out his duties. The business rescue practitioner is in a position where he can fire any employee in the company or remove any employee from their office. In order to remove a director, however, he needs to go to court to have them removed. But yeah, the only real reason to remove a director is if he's being dishonest or if he's really being obstructive, because the business rescue practitioner has ultimate control over the board of directors, and the board of directors ultimately have to do what he says.
Yeah, so just on that score, we've had questions, Ian, in relation to a reluctance by the board to put the company into business rescue because they haven't been that savory with, let's say, their tax affairs. And now all of a sudden they have an outsider who is going to be digging deep, and the tax affairs are completely out of kilter. And in fact, let's say that there's been an under declaration of income to cash books. How does that work?
Okay, so it is, Chapter 6 of the Companies Act says that in our appointment as business rescue practitioners, we are officers of the court. In other words, it is incumbent on us, and the Companies Act specifically spells it out. It's incumbent on us to report any irregularities that we come across, that the directors may have perpetrated in the past, leading up to business rescue. Now, let me point out very clearly that we are not auditors, so we are not there. Our sole purpose is to come in and rescue the company. Our sole purpose, our purpose is not to sit down and try to look for fraud. However, if it does come to our attention that there has been an irregularity, or if the directors tell us that there's been an irregularity, then it is our duty to report it to what the Companies Act calls the relevant authorities. And if it's been an under declaration of tax, then the relevant authority in that case is SARS. Now, SARS knows, and I always say this, and I'm talking from a completely practical perspective, SARS knows that people dodge tax. SARS knows about it. SARS is not there to close companies down. They are certainly not there to put directors into jail for tax evasion. SARS is there, one of their primary objectives as it relates to business rescue specifically is to keep companies going and to sign off business rescue plans, to approve business rescue plans to the extent that they can ensure that the company survives. So in the event, and let's paint the scenario now where we have been told that by the directors that they're running two sets of books and that they've dodged tax, or should we come across that, we're then obliged by law to report it to SARS. What we would do in that instance is we would go to SARS, and SARS very much welcomes these voluntary disclosures, as we call it. We go to SARS and we say to SARS, Company X is in business rescue under our control. The directors have told us, or we have found, that they should have paid R1 million worth of tax last year, but they only paid 300,000 rand. We say to SARS, were we to pay you the R1 million now, A, the company doesn't have the money to pay you. Were we to sell assets and pay you the R1 million or the difference, then there's no way that the company could survive. We'll then say to them, the only way it's going to work, and we'll build this into the business rescue plan, is for us to reduce as part of the business rescue plan, is to reduce the amount that we owe you, SARS, to the amount that was previously stated, for example, or that was declared by the company, being the 300,000 rand. And we will only be able to pay that to you over 2 years. SARS has been very reasonable with us when we put that scenario forward to them. As I said, they're not there to close the company down. They need to approve a business rescue plan that is going to work. It's going to allow the company to survive. Most of the time, they will agree to something like that. In every business rescue, creditors take what we call a haircut in layman's terms, or a compromise. In other words, the amount that the company owes that creditor is reduced to the extent that it can make it viable for the company to survive. And we are given extended payment terms, or we put forward extended payment terms in the business rescue plan, allowing us to pay the remaining balance over a certain amount of time, say a year or two. So that's how we reduce the SARS liability in the business rescue plan. So at the end of the day, most of the time you're better off. A, we've come clean with SARS as to the under declaration, and B, we've reduced the balance owing to SARS so that you're not paying more tax than you would have been paying under normal circumstances. And business rescue has allowed you to pay that off, the balance off, the remaining balance off over a longer period of time.
Right, we got another question which I'll deal with. How is COBRA different to business rescue? So to understand how the statute works, if you're in financial distress, which means there's a likelihood that you'll not be able to pay your debts as and when they fall due in the ensuing 6 months. If you're in financial distress, the board has an obligation to put business rescue to the vote. And if the board declines the vote, says no, they have to set out reasons in a notice to employees and to creditors, setting out why the vote went against business rescue. So you have that obligation to do that if you're financially distressed, as are 90% of companies out there. So if you're going to fulfill your obligation, you have to put it to the vote and you have to write to your creditors. What you say to your creditors is, we're not going into business rescue. We've decided to avoid business rescue by going into the COBRA system. Now, the COBRA system has business rescue practitioners, it has the entire team that a business rescue process would require, that we are going to do everything in our power to avoid you going actually into business rescue. And that's the idea of COBRA. And that's why you can then write to your creditors saying, look, I'm not going into business rescue. I'll try to find the notice that we have a draft notice for businesses to send to creditors saying, hey, we were obliged to put it into the vote, but we didn't because we're in the COBRA ecosystem. Then COBRA tries to rescue the business outside of business rescue. So COBRA is different because it's not just about business rescue. It's primarily about avoiding business rescue. And then if there is really, really a need for business rescue, then COBRA will also deal with that. And all the pro bono elements obviously naturally kick in. Just on the business rescue plan, Ian, and voting, I'll give you the following scenario. You have a shareholder, single director. He or she is owed R1 million, and then all the trade creditors are owed 50,000 rands. You put together a business rescue plan. The shareholder's cheeky because he or she has this massive claim of R1 million and decides to come up with a business plan without the input of the creditors. Talk to me around that. Will that business rescue plan be approved? Can it be approved?
So the Companies Act requires that the creditors, 75% of the total creditors who vote, be it by person or by proxy, and 75% is by value, not by number. The Companies Act requires that 75% of the creditors voting approve the business rescue plan, and that 50% of those creditors are independent creditors. In other words, that 50% of the independent creditors who vote approve the plan. So in the scenario that you painted, the shareholder would, his positive vote for the plan would allow the plan to pass the 75% threshold because he's by far the biggest creditor. However, the trade creditors, being independent creditors, in this case would be required to, 50% of the trade creditors who vote by value would be required to pass the business rescue plan. So in this case, the shareholder or the shareholder and the director working with the business rescue practitioner would need to put forward a plan that is that the trade creditors would approve, or that more than 50% of them would approve. in a practical situation, such as in the scenario that you painted, the easiest thing would be for the shareholder and the director to simply pay the trade creditors. You know, because it's the 50,000 rand, it's a fairly small amount in relation to the total creditors. So easiest would be to pay them off, so that they don't have a vote anymore. Effectively, they don't need a vote because they've been paid, so they can walk off into the distance. And they don't have to pay them in full. They can also negotiate with them to get them out. And in other words, they can buy their claims. The shareholder can buy the trade creditors' claims for a reduced value that has been agreed upon in a negotiation. So in the scenario that you painted, no, it wouldn't pass, because you wouldn't pass the 50% of the independent vote requirement, unless you convince the trade creditors to accept that, or unless you bought out their claims.
Thanks, Ian. Ian, going back to the question, how is COBRA different to business rescue? I think it's important to also highlight that COBRA is very much also involved with Section 155 compromises. And that's technical, it's legal. You have Schindlers who are able to attend to the High Court application that's required, but can you take us through Section 155? This is now outside of business rescue. There's no need for business rescue. We decide, you come into COBRA and we decide that this is possibly the route to go. And then what?
Yeah, so Section 155. So let me just say this, you know, at the beginning when we evaluate the company, there's a lot of options for us, you know, within COBRA. And it's very important that we get it right from the start as to what the best solution is for that company. Sometimes it's business as usual with a little bit of intervention and hand-holding from our side. Sometimes it is, you know, if there are creditors that are bashing the door down, then it's a case of putting it into business rescue. Sometimes the Section 155 compromise is the best option, which I'll explain now. You know, sometimes it's an informal turnaround that takes place outside of the confines of business, outside of the legal protection of business rescue. And in extreme cases, it's liquidation. Liquidation will very seldom be the first choice, you know, that we make. And you know, we as COBRA, and we have always been, and as engaged, have always been business rescue practitioners and not liquidators. We are there to save companies. Sorry, we're not just business rescue practitioners. We are turnaround experts who operate a lot under the business rescue legal framework. So going back to your question, Section 155 compromise basically is often a quicker and a cheaper way for a company to return to a solvent going concern, as opposed to business rescue, which can take longer and can be more expensive. Section 155 compromise basically says that the turnaround practitioner puts together a plan whereby the creditors in the separate classes of creditors are each, their balances are compromised to a certain extent. So the classes that you would look for in this scenario are your secured creditors, your preferent creditors being SARS and employees, and then being your concurrent creditors. So those are your separate classes that you look at under a compromise. Compromise, you would typically say, in order for this company to be solvent, we require secured creditors to take a haircut, or for the balance to be compromised to the extent of, say, 10%. And these are just examples, the numbers that I'm throwing out. Employees, amounts owed to employees would need to be reduced by 20%. Amount owed to SARS would need to be reduced by 40%. Amount owed to concurrent creditors would need to be reduced by 60%. We then sit down and we get the creditors to vote on the plan. And what is required in a compromise is that 75% of the creditors by value who vote in each class of creditors. So you actually need to undertake 3 or 4 separate votes, depending on the classes of creditors. Each class needs to pass that compromise. In other words, needs to vote in favor of the compromise to the extent of 75%. So it's very seldom that we would do a Section 155 compromise without already knowing that we have the support of the majority creditors for it to go ahead. So we get the creditors together, we get them to vote. And should it be passed, should it be approved by the creditors through the requisite 75% vote, then we take it to court. We take the papers, the forms to court, the papers that set out the compromise, and we get the compromise made in order of court. Once it is made in order of court, then the compromise is immediately effective, and the company is then solvent and can continue trading on a going concern basis. The difference between Section 155 compromise and business rescue is typically business rescue, and most of the work actually gets done once the plan has been approved. We call it the implementation of the business rescue plan. That's why business rescues can drag on for a very long time, because once the plan has been approved, then it gets implemented. And then implementation, that's why a business rescue plan asks for 3-year financial forecast, because it is known that business rescues do very often drag on for a very long time. Section 155 compromise typically ends at the stage where that compromise gets made in order of court. It is obviously an alternative for the turnaround practitioner to have the creditors approve his ongoing involvement in the turnaround of the company, but very often the Section 155 compromise is just a legal remedy, a negotiated legal remedy that ends at the time that the compromise is made in order of court. Another important thing to note is that during the Section 155 compromise, while the turnaround practitioner is negotiating with creditors, in other words, before he's had the meeting and before it's been ratified by court, the company does not enjoy the steel blanket around it that we talk about. It doesn't have the protection, it doesn't have the moratorium that business rescue enjoys. So that's an important thing to note. That's why normally 155 compromises would be done where the creditors are relatively friendly. In other words, there's no creditors bashing the door down to try and liquidate the company or to try and attach assets. So that's an important difference between 155 compromise and business rescue as well.
Thanks, Ian. Whilst we conclude, I ask that the audience come up with the final questions that you may want answered. I'll be asking Ian what will happen, or what happens if the approved business rescue plan fails. So in other words, the plan did not work. But before I get there, this is going back to Lance's question on costs of business rescue. I think it's important to also mention what the costs of liquidation are, because a business rescue works on an hourly rate or on a contingency, whereas a liquidation is a set percentage. So it's either 3%, 6%, or 10% flat rate, regardless of depending on the nature of the assets, but regardless of the amount of time spent. So I've seen a case in a liquidation where there have only been listed shares that had to be sold and they were worth in excess of 100 million. And in that case, just think about it, for one sale, a liquidator could get a small fortune. You can have that reassessed by the Master of the High Court, but it's a process. Whereas the business rescue practitioner, I'll give you an example where we were involved in a Camps Bay restaurant. The restaurant was underwater because of the rental costs. We put the company into business rescue, met with the landlord. Landlord understood that there was an issue and that the rental was too high. Landlord agreed to a reduction of rental, and it was in and out. And the fees, the business rescue fees, were negligible, considering what the business rescue practitioner was able to achieve. So it's certainly have regard to the assets, but if you want to rescue the business, but the fees can be a lot lower than a liquidation. So to conclude, Ian, what happens if the plan doesn't work?
The plan doesn't work. So the plan gets approved and we start implementing it. Now remember, the business rescue practitioner is required to put together a business rescue plan within 25 days. That's a time frame we always try to stick to because of the inherent urgency. Sometimes if there's a fundamental paradigm shift in the outlook for the company, such as in the case of SAA, then practitioner will ask for an extension, as they have done. But long story short, it's a small time frame in which to put together the rescue plan. During that time, the practitioner is required to find out as much about the business, learn as much about the business as he can, find out the causes for distress, put together the plan that's going to see that company return to a solvent going concern. Now, that's a big responsibility to do that in a fairly short space of time. Any banker will tell you, and everybody knows that, you know, a cash flow forecast is simply that. It's the best estimate of what we believe the outlook of the company to be in financial terms as of the date that we're putting it together. Internal and external things happen. I mean, you know, COVID-19 happens, for example, which nobody could possibly have predicted. You know, and so I mean, inevitably, you know, that sort of thing causes the financial forecasts to change. And
no one except for Bill Gates.
Yeah, exactly. And when those financial forecasts change, then it can be perceived as being a failure. If creditors will often perceive it as being a failure if they're not getting paid the amount of money that the forecast said they should be getting paid. And in that case, it's up to us to revise the business rescue plan, and that revision of the plan normally takes place under pressure from creditors. And they say to us, "This plan is not working. How are you going to revise it? You said we'd be paid by month 12, but that's not likely. Is it likely we're going to get paid over 24 months? If so, then you need to present a new plan." And we'll revise the plan. We'll take it back to a creditors meeting, and then it's up to creditors to once again approve it the same way they would approve it in the Section 151 or Section 152 meeting. 75% of the creditors at that stage of the game, because the creditors' balances might well have changed. Some of them might have already been paid to a certain extent. There might have been post-commencement finance advanced, in which case we allow the post-commencement financier to then have a vote as well to the extent of the value of his loan. So then the plan gets re-voted. The revised plan gets voted on again. If it is approved, then we carry on with the implementation of the plan or of the revised plan. If it is rejected, then it's up to us to liquidate the company. So yeah, that's how it works in practice. And yeah, hope that answers your question.
It does. Thank you very much. Thanks to the audience. If you want to come into the COBRA environment, send an email to info@cobra.org.za. There's also a fantastic knowledge base on the website which deals with the various funds. There's a whole lot of information there, including the videos, other webinars, specific webinars. Go to the website or the Schindler's Facebook page. You'll find that every week we're going to have industry-targeted webinars. Just today, we're setting one up for the aviation industry. So keep a lookout for those. But we really, really implore you, come into the COBRA environment so we can keep you out of rescue and deal with your creditors. Thank you very much. Thanks, guys.
Thank you very much, Maurice.
Cheers.